Just in, as of this morning, Ivanka Trump has been formally linked to new evidence through a late-stage supplemental filing, triggering an unusually fast response from the court and an immediate public counteroffensive from Donald Trump's camp. What makes this development notable is not simply the existence of new material, but the speed at which the legal process shifted once it appeared. When courts move quickly, it is usually because something has changed in how risk is being assessed, and today's docket activity suggests the case is no longer being treated as routine. According to the court record, a supplemental evidentiary notice was posted alongside a request for an expedited conference, a pairing that almost always signals urgency. In practical terms, it means one party is asking the judge to stop treating the case as an ordinary scheduling matter and start treating it as a credibility and preservation issue. Courts do not accelerate timelines lightly, especially in high-profile cases where every move is scrutinized. When they do, it is usually because the judge believes something could be lost, disputed, or mischaracterized if action is delayed. The sequence leading up to this moment unfolded quickly. Late over the weekend, a sealed docket entry appeared referencing anticipated authenticated records. Early the following morning, a short letter was submitted alerting the court that newly confirmed materials required prompt attention. By the next business day, defense counsel responded with a brief objection, arguing that the timing of the submission was prejudicial. Hours later, the materials were filed anyway. By the next morning, the clerk posted the packet publicly, and the judge granted a same-day conference window. In just a few days, the case shifted from managed pacing to procedural acceleration, a transition that rarely happens without judicial concern. The new evidence itself is not described as a single dramatic revelation. Instead, it consists of multiple categories of records that, taken together, are said to form a coherent pattern. According to the filing, the packet includes communications metadata showing routing and timestamps, calendar records outlining meeting sequences, and transaction-related compliance documentation tied to a specific decision window. Individually, each category might be explainable. Collectively, the moving party argues they establish knowledge, timing, and coordination in a way that challenges earlier characterizations offered by the defense. This distinction matters because courts evaluate evidence differently when it moves from suggestion to connection. Suggestion invites debate. Connection raises questions of intent and responsibility. When evidence claims to connect an individual to a sequence of actions, rather than merely surrounding activity, a judge's role changes. The focus shifts away from managing deadlines and toward protecting the integrity of the record. That shift is what appears to be happening now. Within minutes of the docket update, Donald Trump's team went on offense publicly. A statement was released attacking the process, framing the development as politically motivated and emphasizing familiar themes of unfair targeting and institutional bias. For political audiences, this kind of response signals strength and defiance. For lawyers, it introduces risk. And for judges, it adds noise that does not answer the narrow procedural questions now in front of the court. What matters to the judge is not rhetoric, but what the record shows, how it was obtained, and whether it will still be reliable tomorrow. This is where high-profile cases often fracture internally. Political strategy prioritizes narrative dominance, while legal strategy prioritizes consistency and precision. When those priorities collide, alignment becomes difficult. Public statements can box legal teams into positions they later have to defend under oath. In this instance, the new evidence packet appears to have forced that tension into the open, because it requires the defense to decide whether to contest authenticity, relevance, scope, or some combination of the three. The structure of the filing offers insight into what the moving party is really seeking. One document is an authenticated records declaration from a custodian, someone legally attesting that the materials were pulled from ordinary business systems with timestamps intact. Courts place significant weight on this type of declaration because it reduces questions about manipulation or selective presentation. Another document formally notifies the court of the supplemental evidence and requests guidance. A third proposes specific relief, including preservation certifications, limited metadata production, and expedited review of disputed privilege claims. None of this is cinematic, but it is consequential. Metadata does not argue back. It establishes sequence, access, and timing in ways testimony often cannot. According to the filing's theory, Ivanka Trump is linked to a narrow decision window in which a transaction structure was adjusted, communications channels shifted, and meetings occurred in a sequence that differs from earlier descriptions. The argument is not that one act proves wrongdoing, but that a pattern across records supports planning rather than coincidence. When judges are presented with pattern-based theories, they often move quickly to ensure the underlying data is preserved before disputes harden. What complicates matters further is that the packet does not appear to stop at one individual. By outlining routing paths, meeting participation, and compliance notes, it potentially implicates advisors, staff, or intermediaries involved in execution. That widens the circle of responsibility and changes internal dynamics. Once loyalty becomes legally relevant, people reassess what they are willing to say, certify, or defend. That kind of recalculation does not require guilt to occur. It only requires exposure. The most overlooked aspect of today's development is the judge's posture. Shortly after granting the expedited conference, the court issued a brief order directing the parties to be prepared to address preservation status, authentication challenges, and the narrowest possible scope for immediate relief. Judges do not list those categories casually. They are signaling an intention to move procedurally without appearing political. Narrow moves protect institutional legitimacy while still asserting control. During the expedited conference, the judge focused on chronology rather than accusation. When were the records requested? When were they received? And what exactly is being sought now? The moving party emphasized the custodian declaration and the risk of delay. The defense argued timing prejudice and contextual misinterpretation. When pressed, the defense leaned away from claiming the records were inauthentic and instead emphasized scope and completeness. A common strategy when challenging custodian-backed materials would carry reputational risk. The judge's response made clear that the case would not simply return to normal briefing. While declining to rule on the merits, the court indicated it would rule on process. Preservation certifications were ordered on a short timeline. Requests were narrowed. An in-camera review was scheduled to assess disputed materials without public exposure. This is the judicial equivalent of tightening the room. It moves the battle away from press statements and into sworn filings, where precision matters and contradictions are costly. That shift explains why the public messaging evolved over the course of the day. After the initial aggressive response, a second, more measured statement appeared, emphasizing respect for the court and a commitment to address the issues through proper channels. This dual voice pattern often signals internal scrambling. It reflects an effort to balance political expectations with legal necessity, a balance that becomes harder as procedural pressure increases. It is worth acknowledging that late evidence filings can be tactical, and that high-profile defendants often face intensified scrutiny. Authentication can be challenged, context can matter, and media narratives frequently outrun what records ultimately prove. Skepticism is appropriate, but skepticism does not negate the court's obligation to manage risk. Preservation is not optional, and when new material plausibly threatens the integrity of the record, judges often act early to prevent future disputes. The broader implications extend beyond this case. When courts demonstrate a willingness to accelerate process in high-visibility matters, it influences expectations across the system. Political ecosystems respond to legal acceleration with polarization and fundraising. Markets and institutions respond to uncertainty with caution. And public trust is tested when procedural moves are mischaracterized as political acts rather than administrative safeguards. At its core, today's development is less about narrative control and more about whether the record can be stabilized before it becomes contested terrain. Public figures can shape headlines, but they cannot rewrite timestamps. As the court narrows its focus to certifications, metadata, and preservation, the leverage shifts away from messaging and toward documentation. As of now, Ivanka Trump has been linked to new evidence through an authenticated supplemental packet. Donald Trump has gone on offense publicly. The judge has moved quickly, signaling tighter procedural control rather than delay. The next several days matter more than the next several news cycles, because upcoming certifications and reviews will determine whether the case remains narrow or expands. Deadlines are now in play. Preservation certifications are due within days. Narrowed requests will follow. An in-camera review will test privilege claims. If filings align and disputes shrink, the process may stabilize. If gaps or contradictions emerge, the court is positioned to tighten further. That is how procedural stories accelerate, not through speculation, but through what the record reveals when it is forced into the open. And that is why this moment matters. Not because of the rhetoric surrounding it, but because once a judge decides the clock needs to move faster, the timeline becomes the story. Life moves pretty fast. If you don't stop and look around once in a while, you could miss it entirely.